Today we're going to talk about step up in basis. My name's Gregory Singleton. I'm an estate planning and probate attorney in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities and greater Minnesota alike. Just as a reminder, if you like today's video, please feel free to hit that like and subscribe button. It really does help support the channel. Also, before we get going, a couple caveats. First, this video is for educational purposes only. I am not giving legal advice. This is not the creation of an attorney-client relationship with everyone on YouTube. Secondly, what we're going to talk about today is Minnesota law. While you may live in another jurisdiction and a lot of the concepts and theories, especially the stuff based on federal law that we talk about, will be the same, make sure you talk to an estate planning professional in your jurisdiction before you do your estate plan. So taxes are a major part of estate planning. Now, granted, most people won't get hit with the estate tax. In Minnesota, your estate must be worth $3 million before you get hit with an estate tax. And on the federal level, your estate has to be worth over $12 million before you get hit with an estate tax. However, the concept of step up in basis does make a big difference in many people's lives. And let's explain what that is. So basis is where you purchase a property at, or where you acquire a property, the value. When you sell the property and the property has increased in value and you sell it down here, you're required to pay the taxes on the difference between the basis and the sell price. What if, however, instead of selling the property when you get here, you transfer the property to someone else because you died, either through a will or trust or however? At that point, the basis steps up and is no longer here. The new basis is right here. So when the person you gave the house to sells the property down here for this much, and the value increases by that much, they're only paying the tax from the stepped up basis to the sale price. That's what step up basis is in. It's in IRS code 1014. So let's walk through this with some numbers just to make sure that we understand the concepts right. So Abraham's our guy today. He purchases a house for $100,000. He sells the property for $350,000. Normally he would pay taxes on $250,000, which would be $37,500. That's a pretty steep tax. However, let's say instead of selling the property, Abraham dies, and the property at the time of his death is worth $350,000. If Abraham, in his will, gave his property to his daughter Susie, and Susie immediately sells the house for $350,000, what tax is she going to have to pay? Well, the basis has stepped up from $100,000 to $350,000. So she has to pay the difference between $350,000 and $350,000, which is zero. She pays no tax on the capital gains. If, however, she sells the property later for, let's say, $450,000, she's going to have to pay the difference between $350,000 and $450,000 because her basis is $350,000. And at a 15% tax, that is going to be $15,000 tax. So what property qualifies for a step up in basis? Well, real property is the big one. Houses, land, multifamily units, duplexes, industrial facilities, etc. Also, you can get a step-up basis on certain non-real property, such as investments, stocks, bonds, ETFs, mutual funds. Businesses and their equipment get a step-up in basis. Non-retirement assets, including brokerage accounts, can get step-up in basis. Various miscellaneous things like antiques, art, and collectibles, those get a step-up in basis. And interestingly, Bitcoin. The IRS came out in 2013 with guidance that said Bitcoin gets a step up in basis as a capital asset. Things that don't qualify for a step up in basis, that'll be retirement accounts such as IRAs and 401ks, pension plans, bank money that's in money markets, tax deferred annuities, and certificates of deposit. None of those actually qualify for the step up in basis. So what transfers can we get a step up in basis for? Well, we've already talked about, we're talking about ones that happen at the time you die. If you have a trust, you get a step up in basis. If you have a will, you get a step up in basis. If you have a transfer on death deed and you transfer the property using a transfer on death deed, you get a step up in basis. If you die without a will, without a trust, and without a transfer on death deed, you still get a step up in basis. Major benefit for this is capital gains tax is at this time between 15 and 20%. You can avoid capital gains tax on certain amounts of assets. So that's my take on step up in basis. I hope you liked today's video. If you did like today's video, please remember to hit that like and subscribe button. It really helps support the channel. If you did like this video, there's going to be a new one coming out every other Wednesday. If you have any questions, leave them in the comments below or just send me an email. I'm happy to get back to you. Otherwise, until next time, this is Gregory Singleton from Signature Law.